Constitutional Court has reserved judgment in the Independent Electoral Commission's bid to have the 2021 municipal elections moved to February next year. The IEC submitted that holding the 5th local government elections in October will be impossible. It cited the COVID-19 pandemic, among other arguments. Govan Whittles has been monitoring proceedings for us today, and he joins me now to take us through some of the main points that came out. Hello, Govan. So the IEC, they want to postpone the poll. They're supported by the ANC. What did the IEC say in terms of main arguments today?
Thank you, Sally. Well, one of the main arguments, and certainly the one they placed a lot of weight on, is the fact that the election date being stipulated and the time period being stipulated by the Constitution doesn't necessarily make the date more important than the requirement for the elections to be free and fair. And the IEC making the submission that based on the report by former Deputy Chief Justice Govan Whittles, it's clear that these elections won't be free and fair. And then going a step further, saying not only what happens on election day needs to be considered in this case, the political parties' ability to reach their constituency is also of great importance here. Let's have a look at what Advocate Wim Trangrove had to say on behalf of the IEC.
Why elevate the one constitutional requirement, the time bar, over the two others? What is there to suggest that the time bar should trump the free and fairness? I would have thought that free and fair elections are more important, but the jurisprudence teaches us that all constitutional rights are equal and there's no hierarchy between them. Justice Majid confirmed that again the other day. So that what does one do when the Constitution sets three demands, all of which cannot be satisfied? Do you choose one and not the others? Or do you respond in accordance with the doctrine of impossibility that says, well, if you can't satisfy all, you must do the next best thing, and that is to strike a balance between them.
And what are those who want the elections to go ahead in October as scheduled saying in their arguments?
Well, this argument has become progressively more intricate as today's proceedings have been underway. And this morning we saw a focus of those opposing the postponement of the election on the fact that the Constitutional Court doesn't have the power, as they say, to rewrite the Constitution, amend the Constitution, and that requires a supermajority in Parliament of 75%, and saying that the fact that the IEC didn't go to Parliament with the report by former DCJ Moseneke is also evidence that they're at the wrong place. But then this afternoon, going a step further, and the IEC's contention that the elections wouldn't be free and fair being picked apart bit by bit, and the most intricate of this being the contention that the elections may be free and fair in wards in the Eastern Cape, and they may not be free and fair in wards in Gauteng. Therefore, it's not reasonable for the Constitutional Court to grant an order saying the IEC can postpone this election because they won't be free and fair, because that simply isn't the case across the country, and each of these municipalities need to be looked at. But of course, it was the overarching argument of what precedent this would set if it were granted by the Constitutional Court that got a lot of attention, particularly from the justices of the Constitutional Court. Let's have a look at this bite here by Jamie Ismail, Advocate Jamie Ismail, about this precedent.
This court's decision, if you grant the Commission the relief it seeks, will stand as a precedent. And there is nothing to say that a court in the future, for the best of reasons or the worst of reasons, under the best of governments or the worst of governments, will not be asked by such government and will not grant relief which may abrogate justices any of the rights under our Constitution.
Now, Govan, quite an interesting aspect of this is that Justice Raymond Zondo has been presiding over this. He's in an acting capacity as a Chief Justice. Tell us a little bit more about what that was like to see him not presiding over the state capture inquiry, but actually presiding over the Constitutional Court proceedings today.
Well, he certainly has been asking pointed questions since the matter began this morning, and similarly similar to what we saw at the State Capture Commission, is asking candid questions and sketching hypothetical situations about what would happen if the court ruled this way or that way. And we saw those kind of questions at the State Capture inquiry as well. But let's have a look at this interaction and comments from the Acting Chief Justice Raymond Zondo on why he shouldn't, or why the Constitutional Court shouldn't interdict the upcoming local government elections.
Does this court have competence to interdict an election that will be unconstitutional?
ACJ, it would, because it would be able to, it would be satisfied on the requirements of an interdict. And that's why my third topic on what are these requirements for impossibility, if you were going to entertain this and write a judgment that said, because of impossibility, Section 159 is suspended, amended, adjusted in order to accommodate impossible conditions, then we would need to set out what are those requirements for impossibility. So when if a litigant could persuade you on an interdict basis that there's, the clear right, the obvious, the apprehension of harm, and you would have absolutely clear evidence that in 5 days' time this election cannot happen, or if we went back into a hard lockdown where no one could leave their home to register, campaign, or vote, that would be a hard impossibility finding.
So, Govan, what now? Judgment has been reserved. A decision has to be made pretty quickly. And in the meantime, political parties have to keep planning and preparing, exactly as the ANC is doing this weekend, in fact, with their party list, for a possible October poll.
Yes, I should say Advocate Bud Linder, on behalf of Freedom Under Law, has come back after the break. They just took a brief adjournment at about 4:30. And Advocate Bud Linder should be wrapping up now for Freedom Under Law, also arguing against the application by the IEC. But you're right, a judgment is expected fairly soon, least of all because there's a deadline of Monday for political parties to submit the names of their candidates that will be contesting in the wards as ward councillors and PR candidates. And then, of course, we know that the date of 27 October remains promulgated. So at this point, the IEC is spending money preparing for the 27th of October while it's spending money on this application in the Constitutional Court. And political parties are doing the same. We've confirmed with a number of political parties that they're trying to rush through their processes to make sure they meet that deadline and they're able to launch a substantive campaign. The ANC is sitting for a special National Executive Committee meeting this weekend. It's what they used to call the list conference, where they'll pick their candidates. Also an indication that they're trying to wrap this up fairly soon because they expect that judgment fairly soon.
So just to be clear, judgment has not been reserved at this point, but it's likely to be once they've wrapped up from today. Is that correct?
That's correct, Sally.
All right. So it goes on, but will be reserved, and then a decision needs to happen quite quickly. Thank you very much. That is our reporter, Govan Whittles.